This Honorable Supreme Court of Tennessee is now in session.
Good morning, Council, and everyone watching on live stream. We appreciate Council doing this virtually for us this morning. In just a moment, we're going to start the second case on the docket and if appellant wishes to reserve any rebuttal time, please do so at the beginning of the argument. Mr. Hibbner, you may call the case.
State of Tennessee versus Douglas E. Linville.
Morning, Your Honors, and may it please the Court. Kendall Stivers Jones from the Appellate Division of the Public Defenders Conference. I'm here on behalf of the appellant petitioner, Mr. Douglas Linville, and with the Court's permission, Chief Justice Page, I'd like to reserve 8 minutes for rebuttal.
Thank you.
Your Honors, the dispositive question before this Court today concerns the application of the drug-free zone statute that was in effect in July of 2018, and more specifically, what the phrase additional incarceration means in the context of non-school properties, in this case, a park, for purposes of sentence enhancement. I know the Court is familiar with the facts of the case, but for the video gallery and just to refresh our memories, I'll give a brief factual and legal context. Mr. Linville was convicted by a jury of 5 offenses. 3 of them were felony drug offenses. And because the location of the offenses was within 1,000 feet of Savannah City Park in Hardin County, Tennessee, his conviction thus occurred in a drug-free zone and was subject to the sentence enhancements found in Tennessee Code Annotated at 39-17-432, which is the drug-free zone statute. As the Court is well aware, the statute enhances the sentence in 2 ways. First, it increases the felony by 1 class, and it also requires that the defendant serve a mandatory minimum in-range sentence without any eligibility for release or credits for good behavior. When I say release eligibility in the context of the statute, that's what I mean by parole. Because the 2 provisions are in separate subsections of the statute, and to avoid referring to a bunch of numbers, I'm just going to refer to the class enhancement in the trial court vernacular, which is the kicker, and the mandatory minimum sentence as the 100% provision. And so,
Jones, let me ask you this.
Yes, Judge.
The issue raised in the Rule 11 application and raised in your as stated in your brief is whether the defendant is subject to sentencing at 1 classification higher than provided in the code when the drug-free zone is a park. And you say you should not be raised to a classification. The state, in their brief, agreed with you. So essentially, you win. The Court of Criminal Appeals was wrong, according to the state and you. And I don't understand how, under Hodge v. Craig, you can now raise an additional issue under our rules of procedure. So why isn't the case just over? I mean, if we agree with you and we agree with the state that the Court of Criminal Appeals made a mistake when it raised the sentence classification based on the drug-free zone, why isn't the case over at that point?
Because this court is going to have to examine a greater issue than just the classification in order to get at the answer it needs to ascertain why exactly the Court of Criminal Appeals was wrong when it made that. The transactional question, as I would call it in this case, is whether or not, it was in my application, it was whether or not the drug-free zone for a non-school property would enhance a felony classification by 1 if it was a park. That provision that says it will not be subject to additional incarceration is in Subsection B3. The dispositive question is what additional incarceration means.
Yeah, but you never mentioned 100% mandatory minimum sentence as an issue.
I'm aware.
And I don't want to beat you up over that because, I mean, I could understand it's a valid issue and you're not always thinking way down the road when you're filing those issues, but I'm having real trouble understanding how we could even reach that issue under Hodge v. Craig.
Well, Your Honor, the issue, as I said, is what additional incarceration means. And that's the big issue. The question before this court is whether or not it wants to make a full finding that additional incarceration, it could stop and say, well, it doesn't mean classification, but the one felony classification, but in order to get to that, it's got to first determine what additional incarceration means. The subsection that says one classification enhancement does not refer to incarceration. It provides for a one class enhancement. And just going by that provision, the only things that would limit a defendant at that point from getting a suspended sentence would be the normal restrictions that it's subject to in the probation provision of the Sentencing Act, which would be 4035-503, which means it's got to be under 10 years and not prohibited by any other provision of the Tennessee Code. The only portion that mandates incarceration is that second portion, that 100%. So counsel for state is correct. Your Honor, Justice Lee is correct. It was not raised in the Rule 11. It was not something that the CCA specifically addressed. It did not remove anything from the 100% or correct it in the judgment. But the question is whether or not this court wants to make a complete finding on that, or whether it wants to send this back for us to send it back up through the channels. So it's an issue of judicial economy, but this court's going to have to come to determine whether or not that 100% applies, regardless of whether I had raised the issue or not.
Well, the 100% minimum service is in a different subsection than the classification provision. So
Yes.
What do we make of that?
Well, they all read together. And state points out in its brief, and I mentioned in my response to the state's motion for clarification, and this court in its order said that we would discuss this at which we are. But there are several of the words that are used in that statute cannot be fully understood or given full effect unless you refer to the other portions of the statute. So I think the state specifically argues that provision B, subsection B, is a complete entity unto itself. You do not need to refer to C and D in order to determine the meaning of that. Now,
this is Justice Page. Obviously, if we agree with you and we're going to consider this, I'll say on the merits, we're looking at 3917-432 B, C, and D. Take me through your analysis of the statutory construction and tell us why we arrive at the conclusion you want us to arrive at.
Chief Justice Page, I think the biggest problem, and I'll admit there's an Attorney General opinion from former Attorney General Robert Cooper Jr. that does not agree with me. And the case law, frankly, doesn't agree with me. And I think the reason for that is that there is what we would call in logic a false equivalence between that incarceration, equating an incarceration with a sentence. And I'll explain what I mean by that. So subsection B, the first part says, creates the rule. Any of the drug-free zone properties shall be punished at one classification higher than normal. In Mr. Linville's case, he would go from a D to a C. Now, that in and of itself does not mandate incarceration. The only reading that would get you there is if you equated a sentence with incarceration, meaning that the standard is incarceration, and that's simply not the case. If that was the case, then that would mean that every trial court judge at every sentencing hearing would have to begin with the colloquy for any felony offense, regardless of a defendant's history, regardless of the level of offense. I presume that this person is going to prison unless I find otherwise. And that's simply not the case. Now, I don't know if that's a leftover from the fact that we call probation and community corrections alternative sentences. But in that the main sentence is incarceration, and those are ways to not serve your sentence without being incarcerated. But a sentence is more than just incarceration. and it doesn't automatically mean incarceration. So B1 creates the rule that all school properties and all of the properties that were added in 2005, public parks, libraries, recreational centers, were in the drug-free zone. B3 creates the exception. The non-school properties, as I'll call them, shall not be subject to additional incarceration as a result of this subsection B, but will be subject to additional fines. Now, that can mean one of two things, and I would argue that it means this. Subsection B criminalizes or adds the elements that are required in order to do the drug-free zone enhancement. It also creates the felony class enhancement, the felony class kicker, which does not mandate incarceration. So I would argue that that additional incarceration in terms to referring to itself, Section B refers to shall not be subject to additional incarceration as a result of meeting the elements of subsection B1, namely that the drug-free zone enhancement applies. The only time that incarceration is mentioned is subsection C, which makes a mandatory minimum sentence at 100%, and subsection D, which completely removes parole eligibility. For example, my client Mr. Linville was a range 3 offender, and he was sentenced in count 3 on a class D felony, which would normally be either 8 to 12 years or 10 to 15 years. And anything under 10 years is still eligible for probation, and nothing in section B1 prohibits someone from getting probation for that. The only thing that they would be subject to would be the 10-year limitation. But when you get to subsection C, it mandates incarceration. It mandates that it be to serve. So that's the only provision that takes away the possibility of probation or community corrections or something other than prison. So that, by its plain meaning, has to be the incarceration that B3 is referring to. It's a mandatory minimum sentence. So if the range was 8 to 12 years, the mandatory minimum in-range sentence, what that means would be 8 years, and that would be at 100%. And then the balance of the sentence, were he to get like 10 years, the rest of that would be eligible at the standard 45%. So the practical effect is that when both apply, it doubles almost the release eligibility or the sentence that has to be served. Now, the state agrees with Mr. Linville, and the body of case law, and as well as the Attorney General's opinion, take that same view. But it's our argument that this is because of this, it's fueled by this false equivalence in that subsection B1 automatically, because it increases the felony class, that automatically means incarceration, and it doesn't. Now, in the plain meaning, we argue that it's plain on its face because of additional incarceration. That's the only portion of the statute that refers to incarceration that you don't necessarily need to get to the legislative history. Now, I know this court has looked at legislative history to kind of back it up in some other cases, but the legislative history is overwhelmingly, we argue in our favor that they did not. They had no intention of having additional incarceration. There was no additional fiscal note that was attached. If you looked at if your honors look at the legislative history that's attached to our brief.
Is there, counsel, this is Justice Kirby, is there anything in the legislative history that addresses the application of subsection C, for example?
No.
Is there anything in the legislative history where, I mean, how do we know that they were not talking about the enhanced classification, which also relates to the amount of incarceration? Even taking your point that incarceration is not the same, is not a synonym for sentencing. If they didn't discuss subsection C, for example, how do we know that they even had that in their heads?
We don't. and the state and I have gone back and forth. We can't infer anything from an absence, essentially. So they did not mention that the felony class enhancement was the one that they meant, and they did not mention. They also did not mention that the 100% provision was the one they meant. The only thing that they said was no additional prison time.
Ms. Jones, let me just hone in on that a little bit.
It's just as good.
And that's with regard to the fact that subsection B3 specifically says that there shall not be subject to additional incarceration as a result of this subsection B. Isn't the proper construction then that the additional incarceration that your client might face because the mandatory minimum is imposed by subsection C, not subsection B?
Only if you're equating a sentence with incarceration, and you don't get to that until you get to subsection B, which is why B has to refer to defendant meeting the elements of the offense meeting the elements that would necessitate drug-free zone enhancement application to the sentence. And that point is well taken. The state mentioned that in its brief. But in order for that to work, and in order for incarceration to be given the meaning that we give to it, and not to presume that every sentence in the state of Tennessee starts out with incarceration, and then someone has to work their way toward earning probation or community corrections. That has to be the application. Excuse me. That has to be the application. To that effect, I would also make it clear that this does not create a new rule. This is not something that would be applied retroactively. This is not a federal right or anything that's affected. It's completely a matter of state construction, which is within the realm of, which is this court's discretion in order to determine whether it's retroactive. And it would not be. It would be going forward. I think this court articulated the principles in State versus Minor that it would apply to anything that may be currently in the pipeline for appellate review, as long as it had met the necessary requirements for preserving the issue or under plain air. And it would only apply to cases going forward. It would not have a field of correction of illegal sentences claims, which is why the state makes an argument that the more proper venue would be Rule 36.1 or a habeas. But the sentence is simply not illegal until this court says it is, because right now it's good law. It's how the courts have traditionally interpreted it since the statute has been in effect. So there's not really any concern with that, if that was a concern of the court. And getting back to the legislative history, should the court get to that, there was no fiscal note that was attached to this. So they anticipated absolutely no additional incarceration because of this. While the state's argument that parole doesn't add incarceration, it just gives the person the possibility of getting out earlier because of good behavior. I think that's an academic interpretation that the legislature is not, and certainly when they're doing a fiscal note, is not going to apply. And there is the statute for release eligibility for certain ranges says that a person shall be entitled to a hearing, which is removed when the drug-free zone enhancement applies under this construction.
With regard to the fiscal note, Ms. Jones, though, that the Fiscal Review Committee, if I recall correctly, does not take into account when they're making those decisions the release eligibility date. They're looking at the sentence itself, are they not?
Could you repeat that, Justice Bivens?
Yeah, as I recall, the fiscal review notes in these instances, they're looking at the potential sentence. They're not looking at and assuming release eligibility based on the release eligibility percentage.
No, but there is zero in the discussions between the bill sponsor, the committee, the Justice Subcommittee. There is no discussion that this will cause any additional incarceration. And note that means not just they're going to be serving more sentence. This means 5 new zones were created for a drug-free school zone. So they're doubling potentially the number of areas that are covered under the drug-free school zone. So they would not just be, it would not just affect parole or release eligibility. It affects the number of people whose conditions would meet the qualification for the drug-free zone enhancement. So it would be adding people who would not otherwise be subject to the enhancement with that 2005 amendment, which was done at the same time. So that is how I would interpret that.
Ms. Jones, this is Justice Page. In looking at this, I noticed that Part C of 3917 432, there are only 2 sentences in Part C. The second one has been removed in the 2020 amendments and replaced by something that is much more favorable to the defendant. It makes a rebuttable presumption that the defendant is not required to serve the minimum sentence. In reviewing this case, I mean, that could cut both ways as far as your argument as to what the legislature thought they were doing in 2005, correct?
And that could be. That would not apply to Mr. Linville. He would have been eligible for that had that condition applied. But it's dangerous in this statute to infer how closely the legislature was paying attention to the specific language of this. Now, the language of the language of the provisions that we're discussing today remained unaltered by the 2020 amendments. But what I mean by example, there was a case recently in the Court of Criminal Appeals where even though they had corrected this or made an amendment to this statute, they still had not noticed that after all these years, and as a trial attorney, I never noticed that the statute refers to child care center and child care agency as 2 different entities. And the Court of Criminal Appeals found that there was an ambiguity such that they also needed to analyze the same legislative history that we did. So in this case in particular, it's dangerous to, I think, not dangerous, but needs to be exercised with caution to infer something from silence or inaction on behalf of the legislature in terms of the statute, because it's been piecemealed for many years, and it's simply some of it just simply is not does not flow well and is nothing on the legislature, but sometimes is not written well for practice.
Right.
That I'll turn it over to the state.
Thank you. You may proceed, Ms. Decker.
May it please the court, Catherine Decker representing the state of Tennessee. This court granted review of a straightforward issue with a straightforward answer that does not require this court to look beyond subsection B. The straightforward issue is whether the defendant was subject to sentencing for a higher sentencing classification pursuant to subsection B1. The straightforward answer is no, he was not sentenced to elevated sentencing. And that is because subsection B3 applies directly to exempt the defendant from the elevated sentencing classification requirement. And to reach that conclusion, this court need only engage in a very simple 3-step analysis that only involves looking within subsection B. And first, a defendant who is sentenced for a higher sentencing classification pursuant to subsection B1 is subject to additional incarceration. That seems to be self-evident, and in the numerous Court of Criminal Appeals opinions applying the statute, that proposition has never been questioned. But in his reply brief and in his argument today, the defendant does seem to question that basic proposition by saying that the state and the Court of Criminal Appeals have created a false equivalency between a sentence and incarceration. So let me just briefly flesh that out because it's a foundational point, and it's the point at which the state and the defendant part ways. First, when a defendant is sentenced for a higher sentencing classification, he may be ordered to serve a longer sentence in prison. And it's important at this point to note what stage of the sentencing procedures subsection B comes into play. It's simply at the very beginning stage where the defendant's sentence classification is determined. It's before he's given a length of sentence, and it's before the court orders the manner or means of the sentence. So at that initial stage, when the question is what sentence classification will the defendant be sentenced at, it is certainly true that if he's sentenced at a higher sentencing classification, he can then be ordered to serve a longer sentence, and he can then be ordered to serve that sentence in prison. And it is for that reason that at that initial stage, elevating his sentencing classification subjects him to additional incarceration. And the defendant, in his reply brief and then again in argument, makes much of the fact that a defendant could be ordered to serve a sentence on probation. But the phrase subject to that appears in subsection B3 embraces the possibility of something occurring. The possibility. And the possibility that a defendant could be ordered to serve his longer sentence in confinement makes him subject to additional incarceration. So, of course, if he's initially ordered to serve his sentence on probation, he's actually been ordered to serve his sentence in confinement. And that sentence of confinement is simply suspended. And he can always be subject to going to prison upon revocation of his probation. So for that reason, too, even a defendant who initially receives a probated sentence is subject to additional incarceration if he's sentenced at a higher sentencing classification. So however, in that step 2, subsection 3B's carve-out provision exempts him from being, receiving an elevated sentencing classification. And therefore, the conclusion is that subsection B3 exempts him from being sentenced at the higher classification. And in this particular exact case, the defendant was not subject to sentencing at a Class C felony when he merely committed a Class D felony. The Court of Criminal Appeals erred in finding otherwise, and that should dispose of the entire issue before this court. This court need not look beyond subsection B or make any additional findings to reach that conclusion. What the defendant did not present in his Rule 11 application is the question, what does the phrase additional incarceration mean for all purposes in the Drug-Free School Zone Act? The limited question in the Rule 11 application was, what does subject to additional incarceration pursuant to this subsection B mean in relation to subsection B1? That was the limited application. This court need not extend the issue presented in the Rule 11 application to consider all meanings of that phrase within subsection B3. So defendant has raised a completely separate issue when he asked this court to look beyond subsection B to subsection C's and D and to hold that he's not required to serve a mandatory minimum sentence at 100%. It is unrelated to the issue before this court. It's not necessary. It's not instructive. It is simply a separate issue. Because he did not raise this issue in his Rule 11 application, he has waived it. And first, he still has not acknowledged that it's a separate issue. He has not asked this court to exercise its discretion to decide whether or not to consider the issue. He has still not asked this court to do that. This court, of course, can exercise its discretion at this point, but the defendants never asked this court to do that. And second, if he has failed to raise this issue in a Rule 11 application, he has waived it. He has waived plenary review. So if this court does exercise its discretion to consider the issue, then it's subject only to plain error review, and the defendant is not entitled to plain error review. So let me turn, just assuming that this court is going to look at the merits of the argument. In my brief, I've set out multiple reasons why the defendant's not entitled to plain error relief. But before I turn to those reasons, I want to address an overarching and flawed argument that runs throughout the defendant's reply brief and also throughout this argument. I don't have time to tease out every way in which this flawed argument weaves throughout the defendant's argument, but so then I'm just going to address it as an overarching argument. The thrust of this argument is that subsection B3's carve-out provision, specifically the words additional incarceration, must, according to the defendant, refer to subsections C and D because those subsections mandate incarceration, and according to the defendant, subsection B1 does not contemplate incarceration. The defendant even goes so far as to say in his reply brief that subsection C is the only provision that mandates incarceration and is thus the only thing to which the legislature could have referenced by the term additional incarceration, since B1 does not mandate such. The first and most obvious flaw in that argument is that subsection B1's elevated sentencing requirement absolutely contemplates incarceration, as I have explained earlier. Another obvious flaw in the defendant's argument is that in saying the words additional incarceration in subsection B3 can only reference subsection C, the mandatory minimum sentencing requirement, the conclusion is that subsection B3 does not even exempt him from the elevated sentencing requirement. And that is an absurd result. And that shows the fallacy of the argument and the emphasis on the mandatory nature of subsection C. But perhaps the bigger and most problematic flaw in the defendant's emphasis on subsection C's mandating incarceration is that the current version of the subsection C does not mandate incarceration. According to the current version of the statute, incarceration, the mandatory minimum sentence requirement is discretionary. So if by defendant's argument, the words additional incarceration can only refer to a statute that mandates incarceration, they would have nothing to refer to in the present statute. Again, that's an absurd result that the defendant cannot possibly promote. It's just an absurd result. And it underscores how flawed the defendant's reasoning is to focus on the mandatory nature of subsection C in the first place. So again, that flawed argument is threaded throughout the reply brief and throughout this argument. And everywhere it's used, it is undercut by the problems I have identified. And it cannot be used to determine the intent of the legislature. So turning now to the arguments in my brief for why the carve-out provision does not conflict or nullify the mandatory minimum requirement, sentencing requirement. So first, the words shall not be subject to additional incarceration that appear in subsection B3 do not conflict with subsection C's requirement to serve a mandatory minimum sentence, because that mandatory minimum sentence requirement does not add additional incarceration beyond what the defendant was already subject to. When a defendant is initially sentenced, he is subject to serve the entirety of his sentence. It's just what he's subject to serve. The statute does not talk about the actual days he serves in prison. It talks about what he is subject to serve. And he is subject to serve the entire term in prison. He's not guaranteed good time credits, any kind of sentencing credits, and he's not guaranteed early release on parole. He is subject to serve the entirety of his sentence in prison. And any good defense attorney would tell his client that he would be subject to serve that entire time and could not rest on the possibility of getting out earlier. He's subject to serve that whole time, and subsection C does not add to what he's already subject to serve. But second, subsection B3 is self-limiting. A defendant who commits a qualifying drug offense within the identified zones like a park shall not be subject to additional incarceration as a result of this subsection B. That language is very specific, this subsection B. A plain reading of that specific language is that the exemption applies only to additional incarceration that subsection B1 subjects him to, and that is the elevated sentencing classification. And then it doesn't apply outside of subsection B. And third, subsection C itself provides that a defendant must serve a minimum sentence at 100%, quote, notwithstanding any other law to the contrary. By any definition of that phrase or any word in that phrase, it has no limitations whatsoever. The phrase any other law means without limitation, any other law. And that includes any provision in subsection B. It's important to note that subsection C was in existence in 2005 when the legislature amended the statute to add areas like the park into subsection B. So it knew when it added areas such as a park, it knew about this sweeping unlimited language of notwithstanding any other law. If the legislature had not intended to include the new provisions in subsection B, they could have amended subsection C to be more limiting, but they didn't. Instead, they included self-limiting language in subsection B, and they left alone the broad sweeping exclusionary language in subsection C. And it's as if they took an extra thick marker to make an extra thick line between the two provisions. Subsection B stands alone, subsection C stands alone. And fourth, the legislature has made very clear its intent that subsections C and D be read to apply to all defendants who violate the Drug-Free School Zone Act. When, as has been discussed in 2020, the legislature enacted amendments to both subsections B and subsections C. They left intact the language in both subsections that is at issue in this appeal. So subsection B3 still reads, shall not be subject to additional incarceration as a result of this subsection B. Subsection C still reads, notwithstanding any other law to the contrary. Before 2020, the Court of Criminal Appeals had specifically addressed the very argument that the defendant makes today to this court and had rejected the argument. The Court of Criminal Appeals had also, in several cases, recognized that a defendant who violated the Drug-Free School Zone Act within designated areas such as a park was required to serve a mandatory minimum sentence. The General Assembly is presumed to have known of those decisions when it enacted the 2020 amendments to the statute. If the legislature had not intended the meaning of those statutes to have been read how the Court of Criminal Appeals has read them, it could have amended the statute to correct that reading, and it chose not to do that. And that is a clear indication that the General Assembly intends those sections to be read how the Court of Criminal Appeals has read them. So for those reasons, when the trial court ordered the defendant to be subject to the mandatory minimum sentence requirement, the trial court did not violate a clear and unambiguous rule of law. Therefore, the defendant is not entitled to plain error review on this new and separate issue. So if there are no questions, the state would just pray that the court remand to the trial court for resentencing on count 3 as a Class D felony and deny all other relief.
Ms. Jones, rebuttal?
Thank you, Chief Justice Page. Two things. I'll address the request for relief and then the overarching flaws that Counsel for State mentions. First, we did ask for relief. We included a plain error argument in our reply. And we also noted in our response to the state's motion for clarification that this did not come up until the analysis of the statute became an issue. So we absolutely asked this court to consider this issue, and the court said in its order that this is something that would be briefed, and we did brief it and discussed an oral argument. So we have asked for relief. We have asked for this court to remand for resentencing on the counts for the drug-free zones and remove the 100% release eligibility or the 100% service of the sentence, and instead apply the 45% release eligibility, which is normally applied to a range 3 offender. Second is the overarching flaw, 3 parts of which the state mentions. One, the changes to the statute in 2020 did 2 things. They shrunk the zone from 1,000 feet to 500 feet, and they gave the trial court discretion. The punishment does not change. The trial court simply now has discretion and is not automatically required as a result of a conviction meeting the criteria under 39-17-432 to require somebody who's in a school zone to be enhanced to class and serve 100%, or in a non-school zone. And the normal practice, of course, being in the courts that not subject to the felony classification enhancement, but still subject to the 100%. Those provisions are still in the statute. They're reworded, but they're still there. There is a rebuttable presumption that a defendant is not required to serve at least the minimum sentence of the defendant's appropriate range of sentence. And that's from the 2020 version, subsection C2. The rebuttable presumption is overcome if the court finds the defendant's conduct exposed vulnerable persons to the distractions and dangers that are incident to the occurrence of illegal drug activity. And section 3 says the defendant is required to serve at least the minimum sentence. Any sentence reduction credits the defendant may be eligible for or earn must not operate or permit to allow the release of the defendant prior to full service of the minimum sentence. So no sentence reduction, mandatory minimum, that's still the same thing. That's still mandatory minimum in range at 100%. So we're still talking about the same thing.
Counsel, this is Justice Kirby. I have a question. You agree that the issue regarding subsection C was not raised. It would be within our discretion to address it in some fashion or another. But do you also agree that whatever we say on that is going to have some impact on how the amended statute is perceived? And that has not been even briefed by the parties. Wouldn't it be problematic for us to address your issue and have that have an inadvertent impact on how the amended statute is interpreted? And that hasn't even been argued or come up in the context of a case.
Right. So, Justice Kirby, you are correct. This absolutely would have an effect on the 2020 version, which is not the one that's being discussed here. B, if the court's fear is addressing an issue that technically hasn't been raised on this, that will affect something that it's not been raised on the 2020 statute, the rule of law has not changed. And that's the same reason why it wouldn't apply retroactively. So this court would still be, it's the same rule of law that the court will be ruling on, no matter if it's the 2018 version, it's the 2020 version. And of course, in that case, it would not be advisory. It's the same law. The punishment's still the same. The only thing that it removed was somebody who's driving down I-65 at midnight when there are no kids near school getting punished for a drug-free zone enhancement when Franklin Road Academy is 1,000 feet or 500 feet within where the drugs were found in their car, for example. So it creates a rebuttable presumption that this statute does not apply if vulnerable persons are not exposed, meaning that if it's at night, kids aren't around, nobody's near the park, things like that. So that's
my point, counsel, is that's one of the factors that we would necessarily have to look at is if we exercise our discretion to address your issue, are we going to break something else in doing that?
No. And again, I think if this was not what the legislation is, if this is not what they did not change that portion of the statute, they did not change the punishment, they did not change the subjects that were affected or the areas that were affected by the drug-free zone. The only thing they changed was giving trial courts discretion, and they shrunk the area. So you're not going to be breaking anything by saying that this particular, like it's either all or none. If it's a school and there are kids there, then it's 100% and it's kicked up. If it's not, then neither apply and just the additional fines apply. They left that alone when they amended it in 2020. And absent that, they have to be operating off of the same legislative intent. This court finds that additional incarceration is ambiguous. They're operating off the same legislative intent that they did in 2005. Which
that was an entirely different legislature.
Absolutely.
An entirely different General Assembly.
It is.
I don't know how you can infer what the 2005 legislature meant from any amendment that's enacted in 2020.
No, absolutely not. What I'm saying is that it's dangerous. There are a lot of places where you can infer from an absence in this case from the legislature, and that's a dangerous thing. I think the meaning of this is plain. Incarceration means incarceration. There's no the absurd result that the state refers to and not subject to in classification. It's absolutely not true. You either are kicked up a range and you're still eligible for probation, or you're also subject to the incarceration that's in subsection C. There's no absurd result. It's just a plain meaning that happens to go against a lot of Court of Criminal Appeals opinions and the former AG, but that doesn't mean it's wrong. For that reason, we would ask that this court exercise its discretion and make a full finding on what additional incarceration means, including the classification that was requested in our Rule 11 and the 100%. We would pray for relief that this court remand the judgments for correct entry of corrected judgments to reflect a release eligibility of 45%. Thank you, Your Honor. and state.
Council, for arguing in this manner today, and all those who have watched us on YouTube. Thank you for joining us. This concludes our November 2021 Jackson docket. Mr. Hibner, you may adjourn court.
This honorable court is now adjourned.